Chapter 5. The Fourth Amendment. Governmental Conduct Requirement. The Fourth Amendment to the U.S. Constitution reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." In simpler terms, the Fourth Amendment protects every person's right to be free from unreasonable searches and seizures. Anytime you are faced with a fact pattern containing a search or seizure, there are four basic steps to follow to determine whether or not the search or seizure violates the Fourth Amendment. 1. Was there governmental conduct? 2. Was there a violation of an individual's reasonable expectation of privacy? 3. Did the police have a valid search warrant? And if not, was it saved by the police's good faith reliance? And 4. If the warrant was invalid, or there was no warrant, does the search fit within any of the 8 exceptions to the warrant requirement? Once you have gone through these steps, you will be able to conclude whether or not the search or seizure is constitutional. If you find that the search was constitutional, then the evidence gathered as a result will be fully admissible. On the other hand, if the search or seizure was unconstitutional, then you would apply the exclusionary rule to determine whether the unlawfully obtained evidence is admissible. Over the next several chapters, we will discuss these steps in detail. In this chapter, we will start with the first step, governmental conduct. Let's begin. When faced with a Fourth Amendment issue, the first thing to determine is whether there was governmental conduct. In order to determine whether there was governmental conduct, we simply look at whether the search or seizure was carried out by a government agent. In general, the Fourth Amendment protects only against searches or seizures executed by a governmental agent. It does not protect against searches carried out by private persons. There are several important categories of potential government agents that you should note. 1. Governmental agents include publicly paid police officers, whether they are on or off duty. 2. A private citizen will be considered a governmental agent if and only if they are acting at the direction of the police. For an example, if your roommate searches your room on his own, there is no Fourth Amendment violation. However, if police ask your roommate to search your room, this search would be challengeable under the Fourth Amendment because your roommate would now be acting as a governmental agent. 3. Privately paid police, like security guards and campus police, will be considered government agents if and only if they have been deputized with the power to arrest. 4th and lastly, public school administrators, like principals and vice principals, will usually be considered governmental agents for Fourth Amendment purposes. In this chapter, we began our discussion on the Fourth Amendment, which protects against unreasonable searches and seizures. We learned that the first step in solving a search and seizure problem is to determine whether there was governmental conduct. If the search or seizure was conducted by a governmental agent, then the next step is to determine whether an individual's reasonable expectation of privacy was violated, which we will discuss in the next chapter.